Well, good morning, everybody, and welcome to this Knowledge Miles Lord Mayor's lecture on the early railway age and its influence on the law of England and Wales. I'm honoured to be chairing this event. We have Nick Cook, KC, retired judge from the Central Criminal Court, to talk about the subject. Lucas, next slide, please. So here is a word from our convener. This is me, Ian Harris. I am a director of the Zien Group, and have worked with Michael Manelli, the current Lord Mayor, for more years than we care to own up to, since 1988, in fact. And I was just saying to Nick before the broadcast started that I'm very familiar with the Old Bailey as a street, because in our early days we worked in an office at number 20 Old Bailey, just opposite the Central Criminal Court. I then hastened to add, not inside the Central Criminal Court, just opposite. So this is a fascinating subject, and it's in fact attracted a very large audience. And I think one of the reasons that it has attracted such a large audience today is that despite its seemingly arcane nature, this topic is topical in many ways. As I see it, the railways were to the Industrial Revolution what machine learning and artificial intelligence is to the technology era. And the fact that the law and regulation went through such an enormous amount of change in that period, perhaps 50, 60, 70, 80 years after the Industrial Revolution started, as the second Industrial Revolution came along by dint of the railways coming, I think certainly makes me think that maybe the time is ripe for changes in our thinking around law and regulation in the technology space. So these examples just seem to be full of analogies with some of the issues that we're grappling with today. Next slide, please, Lucas. So you're going to have about 5 minutes of my introduction. I'm almost done. And then a keynote presentation from Nick for about 20 or 25 minutes. And then we'll have a question and answer session. Many of you will be familiar with GoToWebinar, but some of you might not be. There is a question button that you can press and submit your questions within GoToWebinar. Even if you know us well and think you could email us instead, please don't do that if you're watching this presentation live, because the only way that we will see your questions while we're live is through the GoToWebinar system. We're kind of locked in and away from everything else while we're here talking to you. So please submit your questions if you're here live through GoToWebinar. Nick has very kindly said that if we can't get through all of the questions, or if people submit questions later, he will try to look at them, although he is a very, very busy man, and there might be some delay between the submission of a question and him answering questions after today. I won't take you through everything that Nick has said about himself in the paragraph that was online that probably attracted you to come and join us. I've already said he's a retired Central Criminal Court judge and an eminent person. He's a liveryman with the Worshipful Company of Fan Makers, which I think is sort of why he's here for the Lord Mayor's Knowledge Miles series. And also he boasts, or rather reports, that he plays veterans hockey for the Welsh Dragons. He's actually scored an international goal, using his own words in his dotage, quite recently, which I think is a rather wonderful thing to boast. And then harping back to his youth, Nick informs me that his maternal grandparents' house backed onto a railway line in the West Midlands, and he remembers seeing trains such as Ajax and Achilles crossing over each other and making an awful lot of steamy mess near the end of his grandparents' house. So Nick is absolutely steeped in the railways and steeped in law. So I can't think of anybody more suitable to be talking to you and certainly I am unsuitable to be talking to you. So I'm going to hand straight over to Nick, and then discuss this morning's topic with us. Thank you, Nick.
Good morning. Thank you, Ian. Good morning, everyone. It's an honour to be able to give this lecture and make at least a tiny contribution to Michael Manelli's mayoralty. He was a great supporter when I was a judge at the Old Bailey and has been a good friend since. I'm going to talk about the early railway age, which is generally, and I will take it as, the period between 1825 and 1875, and its influence on the law of England and Wales. People who know me well, hopefully not those who appeared in front of me, will realise that I never wanted to be a lawyer. I would have much rather have been an archaeologist or a historian, but my late parents took the view there wasn't enough money in that, and they were probably right. I'm going to deal with company law, compulsory purchase, public inquiries, fatal accident and personal injury litigation, trade union rights, and even sentencing. So that's a long list. I haven't got that long, so I'm going to rattle along. But as Ian mentioned, there are parallels with our own generation's technological revolution in the form of the coming of the internet, digitalization, globalization, and artificial intelligence. I'm going to concentrate on 1825 to 1875, but I'll also deal with some later events where necessary, in particular to explain when some of the disturbing features of the law during the period I concentrate on were eventually dealt with. I should acknowledge my debt in relation to sources, so I'll do that quickly. Three in particular: a book which used to be famous, Read for Danger, by L.T.C. Rolt, who was also the historian of the canals. That was a book I read as a schoolboy and helped me on various occasions, somewhat unlikely but true, in my professional life. The next book, The Law and English Railway Capitalism, by R.W. Costall, sounds dry but is anything but, and D. Nolan, The Fatal Accidents Act, 1846, which is of course a monograph on that act. I'll start off with company law, but I do realise that that's a subject which more will be familiar with in my audience today than some of the others, so I'll take things fairly quickly. But the influence of the railways on company law was enormous. The canal companies, whose activities peaked in the period around 1790, managed to raise capital to the great extent needed by the setting up of private acts through Parliament, but that was cumbersome and expensive. But there was no alternative at that time because joint stock companies had effectively been prohibited after the South Sea bubble crash by the Bubble Acts. It took the whole, really, of the first industrial revolution, if we split it up and take that as the description for the pre-railway age industrial revolution, for things to be worked through and it to be realised as more and more capital needed to be raised, that the Bubble Acts couldn't be allowed to continue indefinitely and the setting up of limited liability companies had to be liberalised. So by 1825, the Bubble Acts were out of date and they were repealed. Somewhat predictably, that was immediately followed by boom and bust on a massive scale. I'll say a bit more about the greatest of the busts, which Costall describes in detail. It's worth reading from him. The collapse of the railway securities markets in the last days of October 1845 left a powerful financial vacuum in its wake. Millions of pounds of capital had flowed through a screen of paper companies. Thousands of men and some women, that's how they used to talk of the gender issue at the time, with some surprise, had staked their all in railway promotions, solely upon the chance of selling their shares, scrip, or letters of allotment for a quick and tidy profit. Tumbling prices left most investors with sheaves of railway paper they were either unable to sell at all or only at ruinous sacrifice. The crash created a vast and tangled web of indebtedness. the spectre of bankruptcy, humiliation, and the debtor's prison drove men into exile and even to suicide. And this is the important part in relation to the effect of all this on the structure of the law in our country. By the end of December 1845, hundreds of lawsuits had already been commenced by railway investors and promoters. By the end of 1846, the three courts of common law, Queen's Bench, Common Pleas and Exchequer, together had issued 24,000 more writs than in the previous year. Well, the medieval structure of the courts, the division of the courts of common law into those three institutions, could not survive that, and the great Victorian reform of that ancient structure had been rendered inevitable by the crash of October 1845. Now, it would take the rest of the lecture for me to deal with the detail of what follows, but the Joint Stock Companies Winding Up Act 1844 comes first, and then other companies law legislation, which gives us phrases or terms which we come across daily in insolvency and companies, such as liquidator and winding up, and they come in short form in 1855, 1856, and the structures then created would be recognizable to us today. So we've got the structures of the courts, we've got company law. Move on quickly to land acquisition. If you're going to set up infrastructure, you must be able to compulsorily acquire land at reasonable value, but that was impossible before the railway age. The canal companies just about managed, but again, you could only act by way of promoting a private act in Parliament. And perhaps it has always been so, those who were in Parliament were not always altruistically motivated. So let me again refer to Costall, because he describes the situation graphically. He says this: the most notorious of such transactions, that is, paying money to a member of the House of Lords, involved the agreement by the Eastern Counties Railway in 1838 to pay Lord Petre the colossal sum, and it really was colossal by the standards of the time, of £120,000, ostensibly for a small tract of his ancestral estate. This bargain, and others like it, was widely regarded as a thinly disguised bribe for support or non-opposition in Parliament. It was no secret, moreover, that the private bill of the Eastern Counties Railway sailed through both houses. So that clearly couldn't go on, and to make things worse, small landowners tended to be undercompensated. They had no influence in Parliament, so they were not going to get those sums. So the Land Clauses Consolidation Act was passed in 1845. That initially provided for compensation to be determined independently by two JPs if under £50 was claimed, a jury or a special jury, that's a jury of particular property holding qualification, or arbitration. And that was the beginning of the system of compulsory purchase and the lands tribunals, which we know today. I don't have time to deal in detail, but it's an important area with parallels today with the local taxation of railway systems. Canal companies had been charged dues in relation to what we might think of as the rates, usefully, on their toll receipts. The problem was more difficult with railways, and there was a great battle. Compromise solution was reached in the end, resulting in the railways, at the height of their success, making a substantial contribution to local taxation. Oh, for such a solution with internet trading. So there is a parallel, the way that had to be in due course was dealt with. Public inquiries. We're now familiar with serious accidents and indeed scandals being followed by inquiries into their causes and recommendations as to how to prevent repetitions following. Perhaps it's no surprise that such things were effectively unknown before the railway age. There were coroner's inquests, as I shall briefly refer to later, but that was all. We're too accustomed now to inquiries taking far too long and seeming to miss the point. What happened, why, and what should be done about it are questions best answered quickly, and I should add, without undue respect for institutions or persons. Our railway forebears seem to have known about that. So again, we're looking at the 1840s. An Act of Parliament, two acts in fact, empowered the Board of Trade to appoint inspecting officers. Originally, and for a very long time into the 1960s, they were drawn from the Corps of Royal Engineers, and they inspected newly constructed lines before they could open. But more importantly for our purposes, they investigated the causes of accidents. And they first started discharging that function in August 1840. And they did, by common consent, a very good job. Although, as Rolt tells us, they were not the inventors of railway safety devices, that was the work of engineers, they displayed almost unerring judgment in singling out the best appliances and urging their adoption many years before they were brought into common use. It would have been better if they could have their recommendations actioned quicker, but the system was, in the fullness of time, very effective. My knowledge of rail safety issues, as I've mentioned or remarked upon earlier, sometimes came in useful in my professional life. In particular, I can share one incident with you. I was instructed by his union to act for a man who'd been severely injured in an accident which occurred when a vehicle he was driving was struck by a train running on the private rail system inside the Port Talbot steelworks. The evidence was that an open level crossing would have shown a red light against him and a green light in favour of the train. The insurers were not prepared to pay. However, I visited the site at night and I happened to be familiar with the Lockington accident, 9 fatalities, 59 injured, and more importantly, the report which was published thereafter by Professor Stott, an independent review of level crossing safety throughout the country. It took less than a year from accident to publication, which is an object lesson. Its significance in the context of that accident is that it was that report that meant that you had to have a black background with edging behind the light that was showing to the traffic. If you've seen Port Talbot steelworks from the M4, you will realise that the number of lights showing in a line of sight to a driver approaching a level crossing would mean your chances of picking out a red one amongst the many of all sorts of colours would be pretty remote. But it was being familiar with Stott's report that gave me the edge in that case, and happily the severely injured man, subject to a small deduction for contributory negligence, got his compensation. Fatal accidents and personal injuries litigation were themselves hugely influenced by the coming of the railways. Before the railway age, no one could recover damages for the death of another in England and Wales. Scotland had a different system. Things changed because of one railway accident in particular and railway accidents in general. People had lost their lives in stagecoach accidents, but the numbers were small and the capacity for destruction limited. With railway trains, it was different. And also, unlike industrial accidents in mining and other forms of employment, all classes were at risk. The famous incident which led to a change was the Sonning cutting accident caused by a landslip on the main line from London to Bristol and South Wales. Number of fatalities amongst workmen returning from building what was then the new Houses of Parliament. So there was an inquest, and at the inquest, what was called a deodand was returned by the coroner's jury. A deodand was another medieval survival, like the structure of the law courts, an instrument or thing which caused the death of a man or woman was forfeited to God, deodandum, given to God. The instrument itself didn't go, so to speak, but the jury would place a value on it, and they placed the value on the engine Hecla. Not a good idea, perhaps, to name an engine after a volcano in Iceland, which Norse mythology thought was the gates of hell, and ironic in the circumstances. They valued the engine at train at £1,000, payable to the crown, but in fact to the lord of the manor of Sonning in this instance. There was an appeal, it was reduced, and so on. Nothing was going to go to the dependents. So that led to a public outcry. Many sections of society thought this had to be dealt with, and it was, by the passing of the Fatal Accidents Act of 1846, allowing for the first time people in England and Wales to sue if they were a dependent for the loss of the wage earner or anyone upon whom they depended. So that was a massive change. Without the railways, I expect it would have come sometime, but it's difficult to know exactly when. Two areas of law of significance which prevented people from getting the compensation we now take for granted need to be referred to. Contributory negligence first. I mentioned that my client's damages were marginally reduced in the Port Talbot case as a result of the accident being partly his fault. But at common law, contributory negligence was a complete defence. Any fault on the part of the plaintiff, as claimants were then called, and they got nothing. Of course, that rule disqualified many deserving claimants from recovering some compensation, even where the weight of blame fell heavily against the defendant. The railway unions pressed this point continuously, but success was not achieved until the passing of the Law Reform Contributory Negligence Act 1945. Thereafter, contributory negligence is dealt with by apportionment in accordance with relative responsibility. Seems obvious, doesn't it? But it was widely resisted for a very long period. I said something about the railway unions. Well, given our collective experience, standing on platforms or not being able to travel when we've had strikes, there may be an ill disposition amongst some in my audience to the railway unions. However, they were most important in relation to these campaigns for law reform from which we now benefit. So in historical terms, we should doff our caps, if that's the right word, to them. Why were the railway unions so powerful and so important? And of course, there are echoes of it today. Because whereas some industries, you can just sack the workforce and carry on in the sort of world we're talking about at the time, that's not so easy to do with the railways, because you are dependent upon a skilled workforce with particular skills. And so the collective bargaining power is higher, and the ability to organise is greater. Before I leave contributory negligence, can I also, in case you're sceptical about it, or the value of changing it to the modern system, indicate that there was an associated doctrine called identification, which made things even worse. And again, it's the railways that flagged it up and led to change a bit earlier in relation to identification. Waite and the North Eastern Railway Company decided in 1858 was an action brought on behalf of a 5-year-old child. The child was travelling with its mother, half-price ticket for the child, full price for the grandmother, I should have said, sorry, I correct myself. They crossed the line to reach the right platform, as was quite common in those days. However, not successfully entirely, because the child was hit by a passing train. The defendants were found to be guilty of negligence in not making better arrangements for crossing the line, but it was further found that the grandmother was guilty of negligence, which contributed to the accident. The doctrine of identification meant that the child was identified with the carer, as we would now call her, and her negligence, and therefore could recover nothing. Although that doctrine was restricted to an extent towards the end of the 19th century, it went completely only in 1948. Common employment and the doctrine of the assumption of risk were important obstacles to employees recovering compensation. And again, they were campaigned against vigorously by the railway unions. Let me tell you a little bit about common employment and the assumption of risk. Common employment effectively meant that you could not recover damages as a result of the vicarious liability of a co-worker. The assumption of risk was a doctrine which had its origins in the English common law, did rather well in America, and then was re-imported back, which held that a worker impliedly contracted to accept all of the risks that were normal in their employment. So you can quickly work out that in the context of railway accidents, this would mean that there were only a small proportion of cases where direct negligence could be shown against the controlling mind of the company, where there was a prospect of recovery. The origin of common employment in terms of it becoming commonly known and having wide application lay in a case called Priestley and Fowler. That wasn't a railway case, it was about an accident involving a horse and cart, but it was immediately recognised as a convenient precedent in terms of the railways. And by way of example, in 1850, it operated to defeat a, as they then were, new fatal accident claim under the 1846 Act, attempted by the dependents of a blameless railway employee. The case was called Hutchison and the York, Newcastle and Berwick Railway Company. There was a modest no-fault system introduced by the Workmen's Compensation Act in 1897, a sort of standard scale of compensation for losing an arm, leg, etc. But it took nearly 100 years from 1850 for the doctrine of common employment to be abolished in 1948 by the Law Reform Personal Injuries Act 1948. The Attorney General of the day, Sir Hartley Shawcross, explained matters to the House of Commons where there was cross-party support for the reform. At a time when, this is what he said, the rights, interests and welfare of workmen were not a matter of such great interest as they are now, at any rate in the minds of those who were engineering the Industrial Revolution, the courts decided that an employer should not be responsible for injuries caused not by his own personal negligence, but by that of a fellow servant. And he went on to indicate how valuable a reform this was. Constraints of time mean that I can only touch upon the role of the railway unions as I've done so far, but it was particularly important. And it was a railway case that led to a change in the law, meaning that unlike at common law, unions could not be liable for causing economic loss through industrial action against their employers. That's the Taff Vale case that was decided against the unions, that was in 1901, leading in short order to the growth of the Labour Party on a very significant scale and the reversal statutorily of the rule enabling employers to recover damages against unions in such circumstances by the Trades Disputes Act of 1906. So we all know how significant that would be. So talking about common employment, the complete defence of contributory negligence, etc., I may have given the impression that 19th century judges were a reactionary bunch, far less sympathetic to ordinary folk than the present generation. So I ought to conclude by redressing the balance a bit. With the railways came manslaughter trials of a different type to anything that had occurred earlier. One such trial followed the Staplehurst rail crash, now largely remembered because Charles Dickens was a passenger on the train and wrote about it in the postscript to Our Mutual Friend. That accident occurred on the 9th of June 1865, and it involved the boat train from Folkestone. 10 people lost their lives and dozens were injured. Responsibility lay with one Henry Benge, the foreman of a gang of labourers who were repairing a viaduct. When asked how the accident occurred, Benge explained, "Why, to tell you the truth, sir, I mistook the time and looked at the Saturday time instead of the Friday." A complicated timetabling system that had to apply to the boat train at that time because of tidal changes. That's the background. So he was duly convicted of manslaughter. Mr. Justice Blackburn, sentencing, told him at the Old Bailey, "You have been found guilty of culpable negligence in the performance of your duty, which resulted in death. The jury, having expressed the opinion, with which I very much agree, that being in command over a body of men employed in taking up the rails ought not to be entrusted to a labourer who works with his pickaxe and shovel at the same employment, Blackburn concluded that a lenient sentence was appropriate. 9 months. He was released after 6 months. There was remission in those days too, but he never recovered from what had happened and died in a lunatic asylum 40 years later. The current sentencing guidelines for manslaughter would seem to indicate a range of between 8 and 10 years imprisonment in such a case, maybe higher still. Back in 1865, from accident to sentence took less than 2 months. The past really is a foreign country. They do things differently there. I'll finish off by telling you a little bit about Mr. Justice Blackburn. He went on to become the first law lord appointed to what was the predecessor to the Supreme Court. Someone in the audience might recall his name because it was his judgment in Rylands and Fletcher, 1868, which laid the foundations for the modern law of nuisance. He was on many other very important cases of the mid-19th century. I think I would have liked him. However, sadly, according to Sir John Hollands, a partner in a predecessor firm to Clifford Chance, when Blackburn informed a colleague that he intended to retire in the vacation to avoid the trouble of a retirement dinner, the colleague cheerfully replied that this was quite unnecessary since no one would have turned up to the dinner anyway, which is a somewhat sad epitaph, but I know the feeling. Thank you very much for listening, everyone. I've gone at a rate of knots. There really is a great deal in this subject.
Nick, thank you so much. I would normally say that was an incredible tour d'horizon, but on this topic, I should probably say it was a wonderful whistle-stop tour. And you don't have to ask how long I spent thinking that one up overnight. Ahead of the talk. We have loads and loads of questions. I'm going to have to group some of them, and some of them I think we'll have to submit to you afterwards. The ones I'm going to group first of all are to do with compulsory purchase. A few people have asked questions about, where does the law on compulsory purchase stand now? And there's one from Simon that talks about that, and there is another one that talks specifically. This is from hold on, somebody else. I'll get the name in a moment. We've got so many have come through. Specifically asking about HS2 and people who've had stuff compulsorily purchased and then it's not needed anymore, but they've already been harmed. How does all of that work now? In 30 seconds.
The answer to that in relation to HS2 is that's not how it was intended to work, obviously. So that's a fairly large-scale disaster, inevitable really because of the cancelling of the scheme, I suppose. I used to act in compulsory purchase cases, and I always thought the system worked pretty well. The judges of the Lands Tribunal were experienced, and the evidence that they heard, it seemed to me, was usually very well prepared in relation to both aspects, whether it was needed or indeed valuation issues. 2 points I've only got time to flag up really where I think there are inadequacies. One is because of the way the system works, and if we had time to go into detail of HS2, we could probably look at this as well. When you're looking at compulsory purchase for a route, be it a railway or a road, the tactic on the acquiring authority would always be to deal with the easy bits first and the agreements, and there'll often be many because the land is not worth a huge sum of money on any basis. And then the difficult bit will be between two bits that have already been acquired and are obvious routes. And so in terms of we need this land, you're likely to be able to say, well, the consequences, if you're the acquiring authority, of not having this little bit to join them up is disastrous because it will have to go around the houses. You get all of that as a problem. In relation to valuation, and I think this is much more difficult, but I've got in mind one case I acted in particular. It always seemed to me, again, this is in the news for a different reason, that the acquisition of land which had been in a family for a very long time, perhaps farming land, in the case that I'm thinking about, it had been in the ownership of the same family. And these weren't great peers of the House of Lords since the 17th century. The acquisition of that land at what might be commercial land value for grade 2 farming, when it splits up the holding and deprives the family of its effectively ancestral farming land, didn't seem to compensate fully. So there's two observations on faults I noticed with the system.
Nick, thank you very much. It was Chris who asked that question. He also asked a question about AI and how maybe we can learn from the laws of the past in how we're deploying AI. And in particular, he said, can we learn the lesson that it might be better to get the law sorted out ahead of the accidents and disasters that lead to the changes in the law, which would be very nice. And Alan Hall also asked a related question, I think. Do you have any ideas on how these past laws might help us to improve the present laws around technology, social media, and that sort of thing? A few reflections on that would be very helpful, I think.
Yeah, I think we're in the world where the appropriate cliche is prevention's better than cure. It was then, it is now, and anything that can go wrong will tend to go wrong, and overconfidence is an enemy. So it was thought that you could work single lines. Let's go back to the railway age for a bit. That you could work single lines, i.e., you could have trains going in opposite directions down the same bit of line, because the timetable would do it. You would give them half an hour to get through that stretch of line, and then the other one could set off coming in the opposite direction. It didn't work. Trains broke down. They used to, they still do, slip on the leaves, so they went slower than they should, and so on and so forth. And it was only the block system that was introduced by the signallers that stopped that. By then, lives had been lost and all the rest of it. So the premise of the question that you're better off anticipating the problems with AI is absolutely right. And the railway age tells us that. Probably people could have sat down and worked out the difficulties. A failure to do so costs lives. So that, I think, is the musing I can come up with on that. Is it's all part of that universal feature of human life, that you should try and anticipate problems.
Nick, thanks. And I noticed a question came in from Charles along very similar lines within a minute of Alan submitting here. So we've had a few on that topic. I've got one here from Graham Elliott, who wonders whether changes to contributory negligence rules allow full damages unless the contributory negligence was considerable. It seems unfair for there to be an apportionment unless the negligence is significant.
Yeah, I mean, they don't. I mean, you can have the developing law meant you never had things like 5% contributory negligence. So the lowest you tended to get was 20 or 25%. So I think that meets the point. It tends, the apportionment under contributory negligence tended and continues to favour a claimant because responsibility or the degree of responsibility is a function of two factors. The burden which is on the party to take care about that aspect, and the extent of the factual contribution of that bit of negligence to the accident. So when it's an employer, or we're looking at railway companies, then they're under a heavy burden because they have all the resources, they are responsible for safety on a grand scale, whereas the individual worker has less of a burden. So you see how those two factors or components will tend to gravitate in favour of a claimant recovering a higher proportion. There are exceptions. When you've got two people of equal status in terms of the burden and the cause, as for example between two motorists, you can get 50-50 apportionments relatively easily. I hope that makes sense.
It does make sense. Thanks very much, Nick. And I think we'll make this the last question before we wrap up, from Nikki, who says, do you have any comments on potential claims relating to climate change or biodiversity loss?
Well, I hadn't foreseen that one, but I think that some of the rules that we can extrapolate from the world of the early railway age would undoubtedly mean that there are areas in biodiversity and climate change where, again, prevention is better than cure. I couldn't cover, but here's an example where the railway world, throughout the days of steam engines and into early diesels, fell down on the job in the sort of way in which we may be falling down on the job with biodiversity and culture change, and that's asbestosis. The beautiful steam trains that went up and down the, it's a good question to finish on, in fact, and I'd not thought of this, so it's quite emotional as well in one way. I'll explain why. So those beautiful steam trains that we, probably all of us, admire if we're lucky enough to see them nowadays, their boilers were lagged with asbestos, and it was used on other parts of the engines. And the first generation of diesels, behind the engine was a sheet of asbestos. When they were taken to the engine sheds to be maintained, the asbestos would be stripped with no proper precautions, although there should have been. As we all know, it was a massive scandal. And as a result of that, men contracted, they were all men, contracted asbestosis. I ought to add, actually, there were women who washed their clothes at home who got asbestosis. That's the nature of the structure. And thousands died, and huge sums had to be paid out in compensation. Now, that should have been anticipated, and it was an environmental hazard. And I think we're looking at the same things on an even more horrifying scale with biodiversity and so on. So the railway age flags that up, that we must be alert to these sort of dangers. I said it was emotional for me, and it was, because you've brought back into my mind a long and interesting career. One of the things I did very early in my career was I would be instructed by the appropriate union to go and visit dying railwaymen in their homes. I remember one particularly in Barry in South Wales, to tell them that the amount of money that were being offered was within the acceptable range. And they were dying and only concerned about their dependents, I might add. So again, it's hard if you haven't done it to understand what that means. But the apprentices, some of them had been very young at the time, they used to play snowballs with the balls of powdered asbestos that would end up in the pit below the engine. It's staggering that there could be negligence on such a scale, but there was, and with fatal consequences. So yeah, it's an object lesson for us all, isn't it? So if people remember that part of my talk, we ought not to allow these sorts of threats to members of society and to us all in the case of biodiversity and climate change to not be anticipated by the best response.
Loads of questions we haven't quite got to, lots of them relating to AI and how AI might relate to this. We will forward them all to Nick. Nick might not be able to answer all of those questions, partly with my Zien hat on and partly with the Lord Mayor's hat on. We are heavily involved, both the Lord Mayor's programme and also Zien in looking at ethics and risk around artificial intelligence and machine learning. There's a lot of material on the Lord Mayor's pages about that, and there's material on the Xi'an website about that if people want to delve into those things. What I would say on AI and machine learning and the like is that there's an awful lot of work going on into trying to evaluate those risks and trying to head them off at the pass with regulation and standards and all of those things. And ultimately, of course, some of these things will end up getting regulated through common law. Lucas, maybe just quickly move on to the next slide. We have one more Lord Mayor's lecture before the Lord Mayor is no more the Lord Mayor and comes back to us at Xi'an. That's Wednesday, the 6th of November. Can AI save us? How doctor data could be the future of health. So having spent today looking at all those risks and horrible things can happen to people, on Wednesday we're looking at all the wonderful things that might come from AI. That really is one not to miss. If you possibly are able to attend that lecture, I shall be listening in for sure on that one. So all that is left, as we've run out of time, is for me to thank you, the audience. You've been a large audience. You've been a very, very attentive audience. I can see lots of you pressing thumbs up and applause buttons. It's a shame. The one thing about webinars, you can't hear that wonderful resounding round of applause that I'm sure everybody wants to give you. So there are lots of stickers coming up on your screen instead, Nick. But they're clearly a happy audience. We're ever so grateful to you for coming along. So thanks to you, Nick. Thanks to the audience, and we hope to see you again on Wednesday and soon on other webinars. Goodbye.
Thanks very much. And can I thank the audience and the Lord Mayor and Zen for giving me the opportunity to give this talk. It was actually very enjoyable researching it, and I am very grateful.
It's been great to have you, Nick. All the best to everybody. Bye now.
Bye, everyone.